Awesome. So we should be recording now. But all right, thank you so much for joining us. So my name is Dustin Atkins, and I serve as the Economic Crisis Response Team Resource Coordination Assistant. So I really help a lot with the back end of everything, kind of the logistics and all of that. And we have a guest today from the Legal Aid Society of San Diego. So if you could go ahead and introduce yourself and tell us a little bit about you, that'd be great.
Yep. Hi, everyone. My name is Danielle Talliart, and I'm the lead attorney on the Fair Housing team here at Legal Aid. And we have just a little bit of background about Legal Aid. We have a lot of different departments and a lot of different teams that can help with a myriad of legal issues. So always give us a good discrimination in housing, and the majority of our clients are tenants.
Awesome. Thank you so much for sharing that. So and kind of the format of today will just be me asking some questions and going through really common things that students a lot of times face as first-time renters or even continuing renters, just things that may happen with landlords and disputes and all of that. So I'll just go ahead and dive right in and start some of the questions. So I guess the first question that we would ask is, what are some important things that students should know before signing their first lease?
So a few things would be, look out for any unusual questions on applications. Sure, the background check where you may need to supply, a copy of a driver's license, something like that. But I have seen where just the early stages of applications, people asking for pictures, I would say that's a red flag. And so there's some protections for criminal history and some questions that they're not supposed to ask and they're supposed to handle in a certain way. And so if the rental application says something about, people with criminal history will automatically be denied or need not apply, that would be a violation. Sometimes we see also in an application something about you're not able to ask for reasonable accommodations or modifications, which is a special protection for those with disabilities. That would also be unlawful. So those are the biggest kind of application red flags. They can ask for social security numbers. That's usually a question we get. Can they ask for that? They can. If for some reason you don't have a social security number, that should not prevent you from being able to apply. That's not a requirement in order to complete the application. And some housing providers will say that they need a social security number in order to complete a credit check, but that's not true. There are other ways to complete that. So that would be another red flag.
Awesome. Thank you for that. Oh, there we go. Definitely some good information, especially for those first-time renters that have never seen a rental application before. And, there's all these new requirements and all that. So definitely some good information to know. I guess kind of going along those lines, is there any advice you give to renters that are first time and looking at, for an apartment or a house, kind of red flags on maybe postings or anything that a landlord might say? You kind of already touched on this, but I guess just anything else that if a landlord says something right off the bat, that's kind of a red flag to avoid.
Yeah. When looking at rental applications, a new law, and this is for the city of San Diego, this new law went into effect, or a similar one went into effect last August. But there's also a new statewide protection for people with rental subsidies. Most commonly, it's going to be a Section 8 voucher. And so ads that say no subsidies, no Section 8, no rental assistance accepted, those are going to be unlawful now. And so if you do have some sort of rental subsidy like that, I would say go ahead and apply anyway if it says that, because it's unlawful for them to deny someone just based on that fact. Also, kind of what we call steering language. So this is language that's going to try to seek particular groups of people. And so a lot of times we see this geared like against families where, they kind of hint at, children may not fit in at this property or something like that. Housing is all about housing choice and having the same opportunity to choose where you want to live as anyone else with the same or similar rental qualifications as you. And so if you're being directed towards, a certain area of the property or something like that, that would definitely be unlawful if it's based on a protected class in fair housing law. So right now, the biggest thing we see is the no rental subsidies or no Section 8. That's going to be the most common violation that we're seeing right now. But it's any language that shows some sort of preference or limitation on one of the protected classes that would be unlawful.
Great, thank you for going over that. Something that we tend to see, or not tend to see, but have seen before come through with the economic crisis response team is individuals saying that their landlord is requiring them to pay a double deposit. Is this something that is lawful within San Diego? And can you talk a little bit about that?
Yeah, so for deposit law, there are some differences if it's a furnished unit or a non-furnished unit. And so the deposit amount can fluctuate from person to person. Housing providers can also determine the security deposit based on credit history or something like that. A lot of times if someone has poor credit history, they're going to increase the deposit, so that they can do that depending on the circumstances.
Great, thank you for that. So one thing that you kind of talked about rental discrimination, not steering and all of that earlier, but we're wondering, what should someone do if they are facing rental discrimination, and how can they fight that? How can they speak to their landlord or take that to court or whatever appropriate channel may follow?
Yeah, so there's a few different enforcement mechanisms. One is, give us a call here at Legal Aid, and if we're able to assist you in some way, we'll of course do that. The most common enforcement mechanism is probably going to be an administrative complaint. So there's two agencies. There's the U.S. Department of Housing and Urban Development, which oversees the Federal Fair Housing Act. And so they have the authority to enforce the Federal Fair Housing Act and make a determination if a violation of your fair housing rights has occurred under federal law. And so that's HUD. There's also a California agency, the Department of Fair Employment and Housing, or DFEH. And so they have the authority to make a determination if a violation of your state fair housing rights. And there are some differences between federal and state fair housing laws. There's also a lot of similarities, but the biggest difference is going to be the state of California has additional protected classes than federal law does. So you may fall into a state protected class rather than a federal protected class, and so you would file your complaint with DFEH. And important thing to remember about administrative complaints is that you have 1 year from the date of harm. So 1 year from the date of discrimination to file a complaint, and then you can only choose one of them. So you may be protected under federal and state fair housing laws, but you can only file with one of them. They won't let you do both. And so you have that option. And then the other option is going to be, file a lawsuit. And so that's, it's a little bit more involved. I would definitely recommend reaching out to an attorney if that's something that you're contemplating before, actually filing it. And for a lawsuit, you have 2 years. So you have 2 years from the date of discrimination to file that lawsuit. So we mainly see administrative complaints. We also, as the fair housing team here at Legal Aid, we'll also try to outreach directly to the housing provider through an formal process called conciliation, which is just kind of like an informal mediation, and we'll outreach directly to the housing provider. Hopefully we can come to some sort of resolution, and so that's kind of a more informal way, but we also do have a lot of success with that. So you have primarily the three options. One is just outreach directly to the housing provider, or an administrative complaint, or a lawsuit.
Definitely, that's some good information, especially for students that may be facing something and feel like there is no path forward. That's definitely really helpful. So thank you for that. A lot of the housing that we have, especially around the SDSU area, requires co-signers, especially if a student's 18, 19, 20, it may require a co-signer. Can you talk a little bit about what a co-signer is and how you should make sure that you're getting a responsible one and all of that?
So having a co-signer or a guarantor basically is there to pay any rent or any contracted, monetary payment made to the housing provider in case the tenant, the actual person living there, is unable to pay. So essentially it is another assurance to a housing provider that rent's going to be paid each month. And so a lot of times, when you're renting your first unit, you may not have a very long credit history. You may not have income yet if you're a student. And so it's really common. And so there are some particular requirements that they'll probably ask of the co-signer or guarantor. A lot of times when you go to apply to a unit, they'll ask you to make 2 times the rent. But with a co-signer or guarantor, a lot of times they'll ask them to make 3 times the amount of rent because they know that the co-signer is paying for their own rent and then is also on the hook for your rental agreement if for some reason you're unable to pay rent. So it's essentially a backup. And so that person will be liable, if you move out and you have any unpaid rent or unpaid bills to the housing provider, they would be liable along with the tenant.
Great, thank you for that. The next one is a little bit more situational, but probably pretty relevant still. And this is about what to do if your landlord is not upholding their side of the lease. So let's say there's something broken in your unit, you're having some sort of issue, but the landlord refuses to fix it. What rights you have as a tenant to make sure that they're upholding their end of the deal? So in a lease agreement, both sides have responsibilities. So, the main responsibility of the tenant is to pay rent. And then one of the main responsibilities of the housing provider is to, maintain the property. So repair requests, things like that, they do have a responsibility to do that. What to do if a housing provider fails to make repairs? There's a few different things depending on the severity of the repair needed. If it's a habitability issue, meaning, someone can't live in this unit unless it's fixed. So that would be really big things like you can't have water or electricity.
It could also be some sort of infestation of insects or vermin. So something that would just make it unlivable or uninhabitable for someone. You can call code enforcement for whatever city you're living in, and place a complaint with them. For possibly smaller repairs that aren't habitability issues, there's a couple of remedies. One is what we call repair and deduct. And so a tenant, has to give the housing provider an opportunity to do the repair. So they should be making the repair request. But if after a certain amount of time, the repair hasn't been done, they can pay for the repair themselves and then deduct whatever they would to show that's the amount that they paid. There's also another one which we don't recommend because it's very difficult to prove, but they can withhold rent. And so if something is a habitability issue or something very, very severe, they can withhold rent until the landlord fixes it or the housing provider fixes it. We do not recommend this because if you're withholding rent, you can get a notice to pay rent. And if the housing provider decides to go through with the eviction after they give you this notice to pay rent, and you have to go to a hearing to prove that you were withholding rent because of whatever repair was needed. And so at that point, it would be up to a judge to decide whether it was proper for you to withhold rent, and it can be difficult to prove. So we just generally do not recommend to do that. If possible, the repair and deduct is better, but also, you can give legal aid a call, and we'll assist you in any way that we can.
And kind of following up on that, would these be the similar routes you would take if there was a repair that needed to be done on the property, or let's say there's an infestation or something like that, and the landlord blamed it on you as the tenant when you did not feel that it was your fault, essentially? Are there routes that you can take still that would be similar to that, or would that be a different route to take?
It would be different because at that point, if the housing provider thinks that, say there's, I don't know, a sink is broken and they think that you broke it rather than it just broke out of normal use. At that point, it does become a factual dispute about what happened. And so that does get a little bit more complicated. And so I would recommend either reaching out to us or, another attorney and getting specific advice on that, because there's a few different factors that could direct down different paths. So I would definitely reach out to someone.
Awesome. Thank you. Let me see here. Sorry, I have my questions right here. One thing that has actually happened to me personally, so I know this from my own experience, is what to do if your landlord shows up unexpectedly, and can they legally do that?
Theoretically, yes, but you don't have to let them in. So if the housing provider comes over one day, knocks on the door, and you have no notice of it. So normally what a tenant would receive is a 24-hour notice that the housing provider wants to enter the unit, usually to make a repair, to inspect something, they have a reason. If you receive no notice and the landlord just shows up, you don't have to answer the door. You don't have to let them in if you don't want to. If they're letting themselves in, that's a huge issue. That is unlawful. At that point, you could call the police if they won't leave, because at that point they're essentially trespassing, because they don't have a reason to be there. The only exception to the 24-hour notice rule is if it's an emergency. So if there's some sort of emergency, like a gas leak or something like that, and they have to enter your unit for that emergency, then that would be fine. But they definitely shouldn't be letting themselves in if you're not aware that they are doing it, especially. But sometimes they'll give a 24-hour notice, and if you tell them, oh, it's okay, I'm going to be at school or I'm going to be at work, it's okay for you to enter while I'm gone, then that's fine, because you have given them permission at that point. But yeah, definitely if they're letting themselves in unannounced with no prior permission or 24-hour notice, that's a very big deal.
All right, thank you for that information. One thing that happens pretty frequently within the college area, especially with college students, is they might be here during the school year, and then over the summer they leave and they have to sublet their unit. Can you talk a little bit about the subletting process and how that works, and what rights tenants have to sublet or may not have to sublet their units?
So if you're able to sublet, it's going to be in your lease. And so some leases will have a specific provision that says you cannot sublease. Some will say you can, but with the housing provider's approval. And so if you're able to, you will have to notify the housing provider if they are asking for the express approval beforehand. And the housing provider is not able to arbitrarily deny a subletter. If you're notifying them, you have the right to do it, and you just are waiting for their approval. They just have to kind of process it like they would any other application. But I would definitely look to your lease. Your lease should kind of outline what you're able to do.
Awesome. And then kind of keeping on the topic of leases, what should individuals look out for when they're renewing their lease? Is there anything in particular that can happen, or anything that they should keep an eye out for when it comes time to renew it?
Not particularly. A lot of times when a lease is being renewed, it's going to be the same terms as, essentially the same copy of the lease that you had previously. So usually there's not any issues with lease renewals. And then a lot of times, we'll see, every time the lease gets renewed, the rent may increase a certain amount. And there are limitations on how much the rent can be increased. So as long as, they're not increasing the rent above that limitation, and it's essentially the same terms as the previous lease, there shouldn't be, any issues.
Awesome. The next question is about rent. So if someone's struggling with rent 1 month, what rights do they have? Can they pay it late, or are they going to be evicted right away? And what does that process kind of look like?
So I'm gonna kind of answer it in two parts. One, during COVID, because there are some certain protections for COVID related non-payment, and then regular times if we weren't in COVID. So normally, if you didn't pay rent, whatever day it's considered late, you would get a 3-day notice to pay rent or quit. And so you would be required to either pay rent during that 3 days or vacate, so to move out during that 3 days. And if you didn't, then the housing provider could go ahead and file an unlawful detainer action, which starts the eviction process. During COVID, it's a little bit different. If you have been impacted by COVID and you've had a decrease in income, maybe reduced hours, or the business you work at has closed, whatever it might be, there's a lot of different reasons that would make you eligible under this new state protection that we call AB 3088. And so under that, if you had, a reduction in income because of COVID, you're unable to pay rent, the housing provider is required to give you a 15-day notice. So this is different than regular. Regular would be a 3-day notice. They're now required to give you a 15-day notice. And then also with that notice, give you a blank declaration form saying for you to fill out, if you're eligible under AB 3088, to say, I've been impacted by COVID, I'm unable to pay rent, and it's under penalty of perjury, and then you submit that to the landlord. You are required to pay 25% of your rent, whatever that is. It doesn't have to be made within the month that it's due. So say, right now it's November. You don't have to make the 25% payment for November in November. It just has to be made by January. So this is for all rent that's due September through January. You just have to pay 25%. And what's really important is you have to turn in that declaration form. If you don't turn in the declaration form, then you actually lose out on all the protections under AB 3088. And if you want some more information about that, our housing team actually put together some really, really helpful FAQs for all the different eviction moratoriums that are in effect on our main website. And so I definitely recommend going over there. It's on our main page if you scroll down, and we have it in English and Spanish. And I highly recommend looking at that. They really break it down, so it's easily digestible, and hopefully it can answer all your questions about the eviction moratoriums there.
That's awesome. That's definitely a great resource, especially because it seems like things are changing so fast these days. And one month this is the rule, and then 1 month this is the rule. So thank you for putting that together and letting us know about that. I just have a couple more questions, and I also want to make sure I'm opening it up. I know we have a couple people here, so if you do have any questions, feel free to just chat me and let me know, or you can just turn off your mic and pop in. So feel free to do that because we just have about 3 left, it looks like. But the first question is about move out, and it's related to security deposits. So it's asking what to do to get your security deposit when you're moving out, and what protections do you have, or what protections does the landlord have with the security deposit?
So about 2 weeks, so there's a few things. About 2 weeks before you move out, you are entitled to request a pre-move out inspection. And so the purpose of this pre-move out inspection is that you would walk around your unit with the housing provider, and they can point out anything that may need to be fixed or repaired before you moved out in order to get your full security deposit back. So they should be doing that, letting you know what needs to be done. Maybe it's repairing a couple of nail holes on the wall, things like that. So then after you move out, the housing provider has 21 days to return your security deposit, or if they're withholding a portion of your security deposit, they're required to return the portion, the refund portion to you, along with, either receipts or some sort of documentation of what they spent your security deposit on, some sort of accounting. And then if they just entirely withhold your security deposit, they should be providing documentation to show how they spent your full security deposit. If after 21 days, the housing provider has not done any of these things, then you're actually entitled to your full security deposit back. So when you're moving out, make sure that your housing provider knows where to send your security deposit or knows how to get in contact with you. Because if you move out and you leave no forwarding address, they're not going to know where to send the security deposit, or if you changed your phone number, after you moved out and they can't get a hold of you, then it may not be their fault that they couldn't return it to you on time. So definitely recommend, keeping in contact with landlord if that's feasible. But yeah, that's within the California Civil Code. And so I think it's a great protection because it requires the housing provider to act fairly quickly. They have 3 weeks, 21 days to return your security deposit. And if for some reason that if they don't, or if you think they unlawfully withheld part of it, then the mechanism to get that back would be going to small claims.
And kind of keeping along that theme, if some of the roommates are staying in a house and other roommates are moving out, can the landlord then require them to pay an all new security deposit, or how does that tend to work?
I don't think that there's necessarily a set rule of how that has to work. If you are going to be moving into a unit with multiple people and each of you are planning on staying for different lengths of time, I would definitely try to work out, before you move in, how that security deposit is going to work, because I've seen it handled a few different times, so it really depends on what everyone agrees to, but that it can get a little bit messy if this discussion didn't happen at a prior time, and then no one really knows what to do. So I would definitely have a conversation with your roommates and the housing provider of how that's going to be handled, because I have seen it where some housing providers will just have a separate lease for each person, and so you're just obligated under your own lease, and so when your lease is terminated or if you move out, then they would have to return your security deposit under your lease, but when it's a shared lease, I would just definitely recommend having that conversation up front.
Awesome. And then I think the last question that we had down is, if you're moving out and your landlord, or you already paid a security deposit, can your landlord also charge you a cleaning fee on top of that deposit, saying you're not getting your deposit back and additionally there's a cleaning fee that you have to pay?
So they can only withhold your security deposit for certain things, repairs, cleaning, things like that. So they can charge you additionally to your security deposit if your security deposit didn't cover all of the expenses that they had after you moved out. So they shouldn't just be withholding the security deposit and then charging you on top of that. If there was no reason to withhold your security deposit, that cleaning fee should be taken out of the security deposit if need be.
Awesome. Thank you for that. Some of these things I've actually been through myself, so it's kind of cool to hear what should have been done or should not have been. So that's actually all the questions that I have on our end. I don't know if anyone who's here had any other questions or wanted to ask while we're here. If so, I'll give you all a second to chat it in or unmute yourself. No worries if not, though. All right. Well, doesn't look like we have any questions from anyone else. Oh, we got one. Awesome. So it says, we also have resources in regards to students with disabilities if you wanted information about that. That would be awesome.
Yeah, so Leon actually works with me over at Legal Aid. And so, yeah, if you guys have any questions about your rights as tenants, feel free to give us a call, and we'll see what we can do for you.
Perfect. Well, thank you for adding that in. With that, though, I think we can go ahead and start wrapping today up. So I just want to say thank you so much for taking the time out of your day to come and speak with us and share your information, because this is a wealth of knowledge that a lot of times students coming in, especially first-time renters, don't know everything and can sometimes be taken advantage of. So it's really great to know that we have this resource and it's available to students. We have the housing hotline right here. Fair Housing Hotline is 844-449-3500. And I don't know if you want to share your contact information or how students should go about contacting the Legal Aid Society in the best way.
Yeah, calling our phone number would probably be the best way. What will happen is you'll get in touch with our intake team, and so they'll start your application for services, and then they'll once you get past the application stage, they'll direct you to the appropriate team.
Awesome. And I'd always recommend students as well come through the Economic Crisis Response Team, because we work with Legal Aid Society and can also help you on the SDSU and with any resources that we have that may be of use. But again, I just want to say thank you so much for taking the time out of your day, and thank you to the few students we were able to get in here today. And I hope you all have a great rest of your day.
All right, thank you for having me.